Yeah. अच्छा हो गया
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 5. Your Lordship, here there's a development in this matter because the department has sat for a meeting, Your Lordship, and they've stated that the rules require a review and examination, Your Lordship.
which will benefit the petitioner.
We are not sure.
We don't know where that might go.
It should.
Your
Otherwise, then there's no point.
The other matter has been adjourned before court number 2,
There's
Lordship.
a similar matter, Your
similar
Lordship, which was pending in court number 2, and we had prayed for time, Your Lordship, here for prayed for 8 weeks time, Your Lordship,
8 weeks.
to let the department review the matter, Your Lordship. I'll just place the minutes of the meeting and the order passed in court number 2.
Let the matter be called up.
Lordship.
Let the matter be called up. This is mentioned R, so
Lordship,
you can't
Lordship
go
has to pass
detail.
orders.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 8, Your Lordship. I pray if this matter can be taken up after 2 weeks, Your Lordship.
On pre-meet by the petitioner, this is matter up to 2 weeks.
Please, Your Lordship, I beg to mention for one unlisted bail application, anticipatory bail application, my lord, for tomorrow. In this matter, my lord, because of some Facebook altercation, my lord, between the petitioner and one individual on a Facebook page, my lord, there's been multiple FIR all across the country, my lord, against this gentleman. My lord, we are here before Your Lordship on a limited, with a very limited prayer, my lord, for a transit anticipatory bail for us to, my lord, unable to exhaust our remedy before the competent jurisdictional court. Since there are multiple FIRs against him, my lord, the apprehension that is that, my lord, if he goes for a regular bail before the jurisdictional court also, he may be arrested. To that limited extent, my lord, we are praying for we are moving this honorable court. My lord, I'm praying for a listing tomorrow. The matter is being filed today. Obliged.
But tomorrow, I think this court will not be there. Some other
Yes,
court will take
yes,
up.
ma'am.
Urgent matter can be taken up by you.
May it please Your Lordship. Lordship, I beg to make a mention of items 6 and 7. These are connected matters, Lordship. Lordship, I'm praying if this matter may be listed after a week's time.
What is the issue involved?
Lordship, this is a service matter where we're challenging the advertisement against the post of assistant teacher, Lordship, Hindi. The petitioner herein was actually posted as a teacher in the school, but because his appointment was purely temporary, we've challenged that advertisement.
On pre-made by the petitioner, not objected to by respondents. Matters adjourned. This is the same after 2 weeks.
6 and 7, sir. Current
6 and 7.
Lordship, highly obliged, Lordship.
Yeah, please, Your Lordship. I beg to mention item number 11. Senior counsel is having some part-heard matter in other court, so it is not in position to appear before this court.
On pre-made by the petitioner, not objected to by respondent. Matter is adjourned. This is the same of the 2 weeks.
Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 4, Your Lordship. Lordship, my senior counsel, Lordship, there was a bereavement in the family, Lordship, so that's why we're asking for time, Lordship.
4.
Number 4, Your Lordship.
Who's for the petitioner? Have you sought their consent?
No objection, Lordship.
You are for respondent.
KHDC, Lordship.
Number?
1 to 3, Lordship.
You don't even have the brief with you.
My apologies, Your Lordship.
What if the court insists that the matter be
Your
heard?
Lordship, 4, 5, and 6, Your Lordship.
Even if you make a mention, always be prepared with your facts.
Yes, Your Lordship. My apologies, Your Lordship.
On pre-made by the respondent 4, 5, and 6.
4, 5, 6, we have Simon William present, Your Lordship. 4 and 5.
4 and 5, Your Lordship.
4 and 5. I oblique KCDC seeking adjournment on ground of personal difficulty on the part of the learned senior counsel who is conducting the matter, the same not being objected to by the petitioner. Matter is adjourned. This is same after 1 week.
Much obliged, Your Lordship.
Supplementary course list, item number 1.
May I please, my Lord? My Lord, by this application under 438 CRPC, the petitioner before Lordship has sought direction of this Honorable Court for the grant of anticipatory bail in connection with UIPS case number 25-5 of 2024 under section 307 IPC, my Lord. My Lord, in brief, what happens in this instant case? On 26/4/2024, there are 4 boys, altogether they are friends. They went for a drive to Shillong, starting from West Dainty Hills. On the way, they consume alcohols, and under the influence of alcohols, the victims and the petitioner herein started quarreling among themselves. The driver of the vehicles, who drive the vehicles, on seeing this, trying to intervene, and for some time, of course, the quarrel has been stopped. Then, seeing the conditions, on reaching the Smith Junction, the driver took a U-turn and returned back home in order to avoid any unpleasant incidents of the night. So, while returning from Smith to their hometown, all of them, since they were hungry, they decided to have their dinner first and then to go homes. And in process, the driver drove the vehicles to the Rajasthan Dabha, which is situated at Kletushi bypass village, on Kletushi village, Juai bypass roads. And they reached the place at about 3 a.m. in the morning time of 27. Now, after having food in the dhaba, for one reason and the other, the victims keep on insulting or quarreling against the petitioner, which situations the petitioner could not control himself. He has responded back, and in the process there was no doubt there was a scuffle inside the dhaba between the petitioners and the accused. However, on seeing the situation, the managers of the restaurant called the other friend of the accused and the petitioner, who at the time came and took both the petitioners and the victims to the vehicles and left the dhaba. So now what happened, my lords? Leaving from the dhaba, both the petitioners and the accused, they went on their own, meaning thereby no one has suffered any injuries, though there was a scuffle inside the dhaba. However, on returning home, on reaching the Kalesken Junction, the place where the victim supposed to get down as his residence has reached, he get down from the vehicles, and unfortunately, while getting down from vehicles, another vehicle came back from opposite direction. So he pick ups. Mahendra pickup came from a opposite direction, dashed the victims, and he fell down to the drains. On seeing their friend has fell down, the driver or the other two of his friend came to rescue the victims. And on seeing his condition, he becoming unconscious, they took him to the civil hospital by the very vehicle which hit him. I mean the offending vehicles. The driver of the offending vehicle took him to the civil hospitals. And the other friends of the victims, together with the accused, follow him from behind by a separate vehicle. Now, my lord, on reaching the civil hospital, the relative and the family of the victim, they came and they decided to shift the victim to Shillong for treatments. And in that event, all his friends, together with the petitioners, they don't know how, where and how he was shifted to the hospital, and then they left on their ways. Now, my lord, on 2nd 5/2002, all of the sudden, the police personnel came to the house of the petitioners, looking for the petitioner to arrest him in connection with the instant case, stating that there was an FIR against him, and a case has been registered on the basis of the FIR lodged by the sisters of the victims. So, my lord, if I may take my lord to the FIRs, page 17, Annex 3. Type copy is page 19. If I may read, my lord. To the officer in charge, so and so, subject FIR, sirs, with reference to subject cited above, I, the undersigned, beg to lodge this FIR pertain to the assault of my brother in an incident that occurred on 27/4 at about 3 a.m. to 4 a.m. at Rajasthan, Daba, located at Kritashi village bypass. On the said date, my brother, namely so and so, was roaming with his friend, whose name is Mr. So and so, son of so and so, residing at Latmukla village. Information was intimated to me and my family to the effect that Mr. So and so is being hit by the vehicle pickup. Thereby, we immediately rushed to admit him to the hospitals, and since then, till date, he is under the ICU at Nazareth Hospital, Shillong. However, today, the 1/4, we have a clue twisting the incident that made us to go to the Daba and observe the footage from the CCTV, and we came to notice that the information which we received earlier stating that he was hit by the vehicle was in fact not correct information. In fact, not correct information, but instead we noticed from the footage that it was his friend, whom we call Mr. So and so, has assaulted him. So based on this FIR, case has been registered, my lord. And then the petitioner being apprehended of arrest on 16/5 approached the court of the district and session judge West Gentle Hills seeking for unanticipated bail. The judge, while admitting the bail applications by order 16/5/2024, was pleased to grant ad interim bail in favor of the petitioner and call for the records. And thereafter, on 22nd, the matter again came up. The IO produced the CD of the case, and after perusal of the CD and hearing of the petitioner on 28/5/2024, the Leonard District and Session Judge declined to grant pay to allow the petitioner to go on bills. So my submission before my lord, as I have already narrated the facts, there are two aspects of the matter. In one aspect, the informant himself has alleged that her brother was hit by a vehicle. Second aspect, she has made an allegation that he was assaulted. So in this regard, my lord, but I would respectfully submit that the part which the petitioner has alleged that he was assaulted by the petitioner, it was investigated by the IO, whereas that part which I have already stated that he was hit by the vehicles was never investigated, nor the landed court below has made any observation while declining the bill of the petitioner. Admittedly, it is on record, the petitioner has brought on record the driving license, the RC of the offending vehicles which hit the petitioner. Now, secondly, my humble and respectful submission, assuming that there was a scuffle, the victim has suffered as the result of the scuffle between that has been taken place at the Daba, but the fact remains, had he suffered, the friend of the accused or the friends of the victim could have been taken him then and there from the Daba straight to the hospital, but that is not there. However, on being hit by the vehicle, then only they took the victim to the hospitals. So at this juncture, my lord, I would pray that CD may be called for, and in meantime, the petitioner may be given some protection.
Yes, Mr.
May it please the Lord. Lordship, kindly see from the contents made in the FIR, Lordship, how the petitioner misled the sister of the victim, telling the sister of the victim that he was hit by a vehicle, which in fact, Your Lordship, in the course of the by the CCTV footage, Your Lordship, it is clear, Your Lordship, that he is the one who assaulted the petitioner, Your Lordship, who assaulted the victim, and the victim he suffered injury, Your Lordship, because he was taken straight to Nasaret Hospital in ICU, and he remained in ICU. Kindly come, Your Lord. Then the learned session judge, Your Lordship, because he moved the bill before the learned session judge at Jawai, Your Lordship. Learned session judge called the case diary, and on perusal of the case diary, Your Lordship, found he had seen the CCTV footage also, Your Lordship. Lordship, kindly come to the order passed by the learned session judge. Lordship will find it at page 30, Your Lordship. Then Lordship, kindly come to para 6 of the order passed by the learned session judge at page 31.
Yes.
He said, Lordship, peruse the case diary and the statement of the witnesses recorded by the IO, more specifically the witnesses who were present when the incident took place. From the statement of the witnesses, prima facie, it emerged that the accused petitioner is involved in inflicting injury to the brother of the informant. And there have been two narrations about the incident, one which discloses about the incident. However, the other is the case of causing bodily injury. The statement of the witnesses recorded during investigation support the theory of causing injury by the petitioner. The CCTV footage of the date of the incident capturing the incident was placed before this court. This court has seen the CCTV footage. The CCTV footage is that of a Rajasthan hotel, and the timing of the CCTV footage is at 3 a.m. in the morning. The petitioner is clearly seen in the CCTV footage brutally landing fist blows to the brother of the informants. The consequence of the fist can be seen on the medical report of the victim. The Lordship, can you see, Lordship? The learned session has seen the Lordship. It is a clear case, Lordship. A clear case that the petitioner is the one who assaulted the victim, Your Lordship. There can be no doubt about it, Your Lordship.
Yes, I think, see, there are, as has been submitted, there are two.
That is
two aspects of the matter.
That is, Lordship, kindly see the FIR, Lordship, very recently, Lordship. That is for the police to investigate on which way the investigation to go, Lordship. That is not the investigation, Your Lordship, is a statutory duty of the police. Petitioner has no, bill applicant has no right, Lordship, to dictate the police, to exactly, do this, to do that. Exactly. He has no right, Lordship. Exactly. Now, this will be investigated by the police,
now
Lordship.
The query of this court would be, if such an information has been, conveyed to the police, for that matter,
No,
as far
no,
as
Your
that
Lordship.
hit and run case is
No,
concerned.
no. This was not
Why was-
conveyed to the police, Your Lordship. This was conveyed by the bail applicant to the sister of the informant, Your Lordship.
No, my lord. Not.
Kindly see the
Yes.
kindly see the content of the FIR. The FIR is very clear, Your Lordship. Very clear, Your Lordship. It was the bail applicant who misinformed the sister of the victim, Your Lordship, that he met with an accident, Your Lordship. Believing, Your Lordship,
Now,
that's
there is also a statement which says that it was the offending, the driver of the offending vehicle, the one who is so-called
Lordship,
offending vehicle.
the CCTV
That could be. See, we are,
footage, Lordship, is
we are,
very clear, Your
we are
Lordship.
dealing in two parts here. First part is the fight or the scuffle inside the dhaba. That is evident. It has happened. The petitioner would not be able to deny that. The next part is the accident part, which happens on the road. Now, he says that it was the offending driver.
Your Lordship, that was a concocted story, Your Lordship.
So that has to be
manufactured by the bail applicant, Your Lordship.
No, non-manufactured, my lord. On record, I have written the RC of the offending vehicle, driver of the
It is a concocted
person who
version,
drove
Your
the
Lordship.
offending vehicle.
Why is the investigation silent on this?
Lordship, I don't have the case diary, Your
You
Lordship.
better just file the CD.
Lordship, kindly see, Your Lordship, the order of Lanet Session Judge. Lanet Session Judge himself has seen the
Yes,
footage,
we have seen
Your
also.
Lordship.
There's no injury, my lord. We have seen clearly from the footage. Of course, we cannot deny that there is a scuffle.
Yes, the extent of injury, that has to be looked at.
Considering, Your Lordship, he has also, the Lanet Session Judge also has clearly mentioned that medical condition of the victim also. So, considering this fact, Your Lordship,
See, the medical condition of the victim would be the result of the scuffle, or if you see, we are not saying it has not happened,
that has to be,
and we are not saying it has happened
that
or
will be
not
seen
happened.
by the police, Your
that-
Lordship.
that
That will
should
be seen by the police because it's under investigation, Your Lordship.
Let the IO file a report in that as far as that aspect is concerned.
My lord.
Just convey to the IO.
Lordship.
So how soon can you file the CD?
This
Today we are on
6, Your Lordship. Let it be on 13, Your Lordship.
13.
14, my lord.
14. Today we are on 6.
We are 6.
Let it be on 13, Your Lordship.
14, my lord.
Why 14?
14, my lord.
No, not on 14. Let it be on or 11, 11, Your Lordship. Let it be on 11.
11.
So meantime, my lord, some protection.
Lordship, seeing the condition, Your Lordship, Lordship, in my humble and respectful submission, not is a fit case for.
The only doubt that this court has is whether it is not, you see, like again, it is not denied that the scuffle has taken place. Maybe injury has been inflicted upon the victim, but the extent of such injuries vis-a-vis the injuries which would have been sustained if the accident actually happened.
As have submitted, Your Lordship, that motor accident, Your Lordship, is a concocted story, Your Lordship.
That will come out in evidence. That will come out in course of,
Your Lordship.
That will come out in course of investigation. If the police says there is no such thing, then heard Mr. Sensuna, counsel for the petitioner, who has submitted that this application is with a prayer for grant of pre-arrest bail. On behalf of the petitioner, who is said to be wanted in connection with Joy PS case number 25, 5 of 2024, under section 307. The court has taken into consideration the submission made by the learned counsel and also the objection raised by Mr. Indishulai, learned AAG. However, to satisfy this court as to the factual aspect of the matter, since there are two versions of there are two parts as far as the cause of the injuries sustained by the alleged victim is concerned, the case diary is required to be produced. Accordingly, the IO is directed to produce to cause production of the case diary of the Joe IPS case number 25/5/2024 on the next date fix. As prayed for, list this matter on 11th. In the meantime, the petitioner is allowed to go on interim bail on condition that he shall not abscond or tamper with the witnesses or evidence, and that he shall appear for the IO as and when required. Order passed accordingly.
Obliged.
11.
Apply.
Daily list item number 1.
May it please, Lordship. I file the affidavit of service, Your Lordship.
You have filed?
Yes, Your Lordship.
Lordship, I'm praying just for a week's time to file the affidavit.
Just a moment. As far as
Respondent number 1.
Respondent number
2, I filed the affidavit. Respondent number 2.
2 and
Only 2, Your Lordship. I filed the affidavit of service.
anybody appearing for respondent 2?
And for respondent number 3, Your Lordship. Similar prayer.
So 2 has not yet appeared. Who is respondent 2?
Darbar of Himalangrin, Lordship. The chief, Your Lordship. The chief of Darbar Himalangrin.
Miss Counsel for the petitioner, who has submitted that the notice issued upon the respondent 2 has been affected, and in this connection the affidavit of service has been filed to confirm such fact. Annexed to the affidavit is a copy of the track consignment issued by the post office, wherein is indicated the date, time and remark, which shows that on 14/5/2024 the item under bracket notice was delivered to the addressee. The Learned Counsel has submitted that this would indicate that the notice has been effectively issued and received by the respondent number 2. The respondent number 2 is not in attendance today. He is, however, allowed to enter proceedings and to file his counter affidavit. As far as the respondent number 1 and 3 respectively are concerned, the Learned Counsel appearing for such respondents have sought for time to file a counter affidavit. Pre-allowed. This is matter up to 2 weeks.
Item number 2.
heard Ms. Z.E. Country, Leonard J. was submitted that the the concerned department has looked into the case of the petitioner herein, only of the petitioner or other similar situated
Only
cases?
the petitioners.
Petitioners, Your Lordship.
Only look into the case of the petitioners herein, no? And to this effect, a copy of the minutes of the meeting held in the office chamber of the Director of School Education and Literacy, Meghalaya, Shillong, on 9th April 2024 have been produced before this court. The Leonard J. has also submitted that in a similar case involving similar issues, which case is before a coordinate bench of this court, similar prayer has been made and the Leonard Court had deferred the matter in the case therein on this ground. Accordingly, it is prayed that this matter may be kept in abeyance. This matter may be kept in abeyance till further till a report is filed as far as the decision of the concerned department is placed before this court. Mr. M.L. Lumpio, counsel for the petitioner, has no objection to the prayer made. No objection. Accordingly, on consideration of the submission made, this matter stands adjourned. The state respondent is directed to file a related report on the next date fix. Within 4 weeks, the matter will be over.
Your Lordship, I'm praying for 8 weeks' time, Your Lordship.
8 weeks.
Yes, Your Lordship.
2 months.
List this matter after 8 weeks.
Obliged, Your Lordship.
Should we fix a date? The other court has fixed a date, same date.
Yes, Your Lordship, it can be on the same day.
Lordship.
This is matter on 1/8.
Obliged, Your Lordship.
Item number 9.
May it please your Lordship. Lordship, the matter is still pending in the division bench, my lord.
Lordship, this matter is regarding the tender that was floated by the state for operation of a central bonded warehouse. So the matter is still pending before the division bench, Lordship.
The matter is coming up on the 19th, Lordship. On the
19.
Before the division bench, my lord.
The learned counsel appearing for the parties have submitted that the related matter, which is pending before the division bench of this court, has not yet been disposed, and accordingly it is prayed that this matter may be adjourned for the time being. On prayer made, matter is adjourned. List the same after. We are 3 weeks.
Highly obliged, Lordship.
Item number 10.
May it please Lordship. Lordship, In this matter, we have already submitted the note of argument as well as the record, Your Lordship.
The matter was posted for pronouncement of judgment, Lordship. Then after that, my Lord, again, because
of the
the
records
was not available, then my Lord, only with regard to, I'll take only 2 minutes, Lordship. I'll not make any submission, Lordship. I'll just
You're not
revert.
making any submission, then why would you take 2
No,
minutes?
Lordship, I have objection, Your Lordship.
Elaborate submission, Lordship. That
Lordship, I have objection, Your Lordship.
But you see, Mr.
Only with
I
regard
have
to the
objection, Your
admission of
Lordship.
charge, Lordship. Only with regard to the admission of charge, what my learned senior has.
See, then you're going back to the merits.
Yeah.
Lordship had already
Lordship.
kept CAB, Your Lordship.
No, I am not going into the merits, Lordship. What my learned senior has cited, I am just distinguishing his judgment, because that judgment my learned senior has copied only 3 paragraphs. Only 3 paragraphs.
What you can do, see, Mr. Sheikh, what you can do, he has, if he has cited certain judgment, and you want to cite, counter judgment, you do that.
I'll not cite any counter judgment. I just only want to submit before your Lordship, is that Lordship, that it is not a case where I was imposed the penalty of dismissal based on the admission, so to call that admission. It is not a case, Lordship. Here, Lordship, that judgment what my learned senior has cited, that he has admitted, after that during the inquiry again he has admitted, Lordship.
Fine, you do that. You file a 1-page.
Oh, I'll
bullet point.
Lordship,
I'll just.
Your Lordship,
because
give it a CAB, Your Lordship. I leave it to Your Lordship.
Yes, because it's only.
Otherwise, I'll leave it to your Lordship. Otherwise, Lordship.
But if you want to,
yes,
you can do it.
Because only that part, I'll just do.
Because
within a week, Lordship.
That would be on law points. So
yes,
okay.
Only on law points. Yes, Lordship.
Mr. Additional AAG has submitted that the relevant records as called for by this court has been today you produced.
No, last time, Your Lordship. Last time, I think it is there.
Has since been produced for this court.
Forgot what.
I'll not comment anything in the.
No, Lordship.
Do that. Accordingly, this matter is now reserved for judgment.
I'll just only reflect only one point, Lordship.
Fine.
You do it.
Master.
Apply, Your Lordship.
Item number 12.
May I please, Your Lordship? Your Lordship, we are supposed to file a proper chart in respect of the deposit made towards the dues of the employees. However, the concerned person from the school are out of station, Your Lordship. Can you give us another date? After 2 weeks, Your Lordship.
Oh.
Well, Lordship, here the petitioners are to file a Lordship, if I can recollect that the Lordship they have deposited, but it was not with respect to the name of the name of the employee.
Yes, I think that was I think that was the query of the court.
Yes, Lordship.
But they have not been able to file it even today.
Yes, Your Lordship.
So do it on the next date.
Yes.
The person is not available. It's very technical.
Miss counsel for the petitioner, who has submitted that this court by order dated 21/5/2024 has directed the petitioner to produce a chart indicating the relevant information as far as the names of the employees are concerned, particularly those who are due for the benefit under the EPF Act. However, the said chart could not be produced today since the official concerned is out of station. Accordingly, as prayed for, the petitioner is allowed to file this said chart on the next date fix.
Oblige, Lordship.
This is matter of
2 weeks, Your Lordship.
2 weeks.
Highly obliged.
2 weeks then?
Oblige.
Item number 13.
In the last order, Lordship, the LCR was called.
Yes, sir. Just come.
What is your case here?
My lord, here, this case pertains to, my lord, some issue in the East Jaintia Hills, my lord, wherein 2 social workers were, my lord, assaulted.
Okay.
And, my lord, randomly, my lord, those cool businessmen who were there, they were picked up, my lord. And in the process, even the petitioner was, my lord, also, my lord, added as an accused in this instance, my lord. We had, my lord, the matter was argued thoroughly before the London Special Judge. And, my lord, the against other accused, I'm not commenting. Against my accused, my lord, the only issue was with regard to, my lord, CDR report, my lord. And it was whole that, my lord, there is enough materials on record, even the CDR, wherein the accused person's involvement is clearly shown. Whereas, my lord, there is nothing on record to show in any way, my lord, the involvement of the petitioner here, my lord. Neither the CDR, my lord, nor other evidence, my lord. That is my case, my lord. So, in that respect, my lord, on the last occasions, my lord is pleased to call for the, my lord, the case record, my lord.
Sachit, what is the stage of the case? Huh?
Stage, my lord, recently it has been informed that frame of charge. It is pending for frame of charge, my lord. In some against some accused, my lord, it has been framed, and against some, my lord, is still pending, my lord.
So what happened is you have come before this court on the order. Was the impugn order?
Yes, my lord.
For
my lord, we had filed an application for discharge, my lord.
So,
discharge. And that was rejected, my lord. Against that, my lord, we have assailed.
Rejected. Trial court.
See, the trial court would not would be in the best position to go to the records, go to the charge sheet, and all.
That was not done, my lord. For that reason, we are compelled to, my lord, assail that order before the Honorable Court, my lord. That was not done. We have advanced the argument, placed certain points of argument before the London Trial Court, my lord. That has not been addressed to, which has compelled us, my lord, to approach this Honorable Court by of this application, my lord. That is all immediate grievance, my lord.
Apni records? So the matter, I mean, the case is still proceeding.
Yes,
still proceeding. He's one of the chargeted.
When is the next date?
11/6. Next date is on 11th, my lord. 11/6.
11/6.
Yes,
that'll be Tuesday.
Tuesday.
Records have not yet. The records are still there.
Yes.
No,
It hasn't received.
Not yet here. They are still
in
the judicial branch.
Lordship, because we will require some time also, Lordship, to produce the case records. So if we can have it after, because 1 week or 2 or 3 days, next week.
See, because the court would not like to hold on to the records. That would not be proper.
Lordship. Otherwise, if my lord allow me to make a prayer, what can be done, my lord? The photocopies can be kept, my lord, and the original can be returned.
It has to be.
That can be done, my lord.
Because the record would, you see, the record would be privy to the prosecution.
Absolutely, my lord.
So, under the circumstances, I think Mr. Karmi, you go through the record.
I would like to go through the records.
See what is relevant.
Yes.
Photocopy those.
Yes.
And then that is also in the presence of the court master. Do that, and on Monday, take up the matter on Monday.
Okay.
In the meantime, I'll send back the record. Had you see, if the case is fixed sometime in on 12, 13, 14, then we can still.
Lordship.
Oh, bulky.
It's a very bulky case record.
For that reason, my lord.
Only the relevant portion, as
Yes,
far
Lordship.
as the petition is concerned. Only that portion.
The statement of one accused was recorded under section 164. That one will be relevant.
Whatever. When the matter came up for hearing, the learned counsel, the learned Mr. H. Kami, learned additional PP, has submitted that the prosecution would refer to certain portion of the materials on record. However, since the case involves a number of accused persons, the petitioner being one of them, only the relevant portion as regard the involvement or where the name of the accused is referred to, that portion would be relevant for this court to peruse the same. It is also submitted that since the complete case records have been called for by this court, and also since the matter before the trial court is fixed on 11/6/2024, so as not to prolong the, so as not to cause any disruption in the ongoing trial, it is submitted that it is prayed that the prosecution will be allowed to peruse the records and to take out copies of only the relevant portion, and also that the record may be sent back to the trial court. The learned counsel for the petitioner has no objection to this submission made and has prayed that this matter may be heard on the next date. Accordingly, the prosecution is allowed to take action as far as the prayer made herein is concerned. The same is to be done within the course of the day, a stop. The records are directed to be returned to the court concerned. In course of the day. Oh, tomorrow is Friday, isn't it? Thought tomorrow is Saturday. In the course of the day, directed to be returned to the court concerned within 11/6/2024. The matter will come up for hearing after 2 weeks. So you take out only the what is. You have a photo machine in your office here. No? You can do that.
I'll go through and I'll obtain only the
it would
relevant.
be better also. You see, on a separate sheet, just note down whatever you have, so that it'll correspond with the
records.
Otherwise, if you just plug here and there and then compile it, it might it might be very confusing.
To refer also, it will be easy, my lord, if it is written that way.
Yes, Lordship.
Please do that.
I'll do.
You can give, My name, my colleague's name.